Mr. Gwatney, in clause number 25, DCCR 0736, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements, and that's from March 5th of 2025. And how do you plead to that charge?
I guess guilty.
Well, there's no I guess. Either you did it or didn't do it. So are you guilty or not guilty?
Guilty.
Are you entering your plea of guilty freely and voluntarily? Answer out loud, please.
Yes.
Did anybody force you to plead guilty today?
No.
Okay. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Gwatney is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirements, sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
And notice the judge says credit for time served, only for time the law allows. That's her saying, I'm not doing vibes, I'm doing statutes. It's sterile, but it's the system.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Can I ask you one question?
Sure.
Whenever I was brought back from Oklahoma, I had 6 months left on my 3-year sentence. They sentenced me to ISF until discharge. Why was this charge that is being brought up on me now not brought up on me while I was being incarcerated back in ISF for the last 6 months?
How would you think I would know that information? I have
Huh?
no idea. I have no idea. I
have gone over the time frame with him. From what he told me, the time frame that he was in ISF was after this case was filed.
yeah.
Case has been indicted over 6 months.
Yeah,
Yeah, and
I don't
he-
know. I don't know why that didn't happen, sir. I'm not sure if it was
The
something.
charges were supposedly filed in June of 24, and I was arrested in 25.
These charges are from March of 2025, sir. And you
25.
just pled guilty to that and it's done. You got your 2 years. You can go back with the bailiff, okay?
Okay.
I don't know the answers to those questions. Mm-mm. That is still.
You just pled guilty. It's done. That's the harsh reality of court finality. Once you plead, most of your options shrink instantly. And the defendant's question is emotional and logical. Why didn't this get filed earlier when I was already locked up? But the judge's answer is also real. She's not the prosecutor, and she doesn't control charging timelines.
All right, sir, you are Michael Murillo.
Yes, Your Honor.
And Mr. Lewis, will your client waive the formal reading of the indictment in each case?
He does.
Mr. Murillo, in clause number 25, DCCR 0377, you're charged with the state jail felony offense of fraudulent use or possession of a debit or credit card from October 16th of 2024. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in clause number 25, DCCR 0378. Just a second. I'll just need my tablet to go faster. You're charged with the state jail felony offense of burglary of a building from January 23rd of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? Speak up, please.
Yes, ma'am.
Thank you. In cause number 25, DCCR 1078, you're charged with the state jail felony offense of burglary of a building. And this is from March 27th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
Clause number 25, DCCR 1079, you're charged with the state jail felony offense of burglary of a building. And that's from April 29th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in 25 DCCR 1516, you're also charged with the state jail felony offense of burglary of a building from April 30th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
Finally, in clause number 25, DCCR 1517, you're charged with the third-degree felony offense of possession of a controlled substance from January 29th of 2025. The indictment alleges that you were previously, well, are we going on count one only? So the state's elected to proceed on that count only, which is that possession of third-degree felony from January 29th of 2025. And how do you plead to that charge?
Guilty.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
In all of these cases, I have here on the tablets documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Williams?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection, Judge.
It's amended in each case. Is there any evidence that Mr. Murillo is not competent?
No, Judge.
All right, sir, in all of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. In cause number 25, DCCR 0377, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of fraudulent use or possession of credit or debit cards. Sentence you in accordance with your agreement to a term of 20 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25, DCCR 0378, you're charged, I find you guilty now of state jail felony offense of burglary of a building. Sentence you in accordance with your agreement to a term of 20 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25, DCCR 1078, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your agreement to a term of 20 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 25, DCCR 1079, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your agreement to a term of 20 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 25, DCCR 1516, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your agreement to a term of 20 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 1517, find sufficient evidence to find you guilty, and at this time find you guilty of count 1 in that indictment of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All of these sentences will run concurrently, which means together at the same time. And Anna, I missed checking one. Anna, Mr. Lewis thinks that there's one where he accidentally checked consecutive instead of concurrent. Would you double check all of Marilla's to make sure they say concurrent on them, please?
Yes.
Thank you. So they will run concurrently, which means together at the same time. I'm going to hand you in each of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff.
Thank you. Thank you.
I'm going all over the place with finding short in that. I did it a little bit on one.
The next part.
I know you already know it. Okay. Carlos Rodriguez, are y'all ready on that?
Morning.
Good morning. Okay. Good morning. You're Carlos Rodriguez?
Yes.
And so, Mr. Salinas
Yes, right.
has been here before, and we went through some motions, and I granted, I guess, an order for the investigator for Mr. Salinas and the investigator for the Assistant District Attorney's Office to get together at an appropriate time for that investigator to walk through, take pictures if necessary, not touch anything in that home. And is
Yes.
that why we're here today?
Yes, Your Honor. It has not been done as of today. I've sent multiple follow-up emails to Kobe. I understand that new district attorney.
Yes, Ms. French is new on this, so I'm
Yes.
sure she's gotten up to speed. Good morning and welcome.
Good morning, Judge. Thank you.
Yes, Your Honor, but I mean, I've made all good faith efforts. I've put the state in contact with my investigator. I've made diligent follow-ups throughout the last month. And it seems that the order has not been carried out.
And Mr. Gertz, why are you here standing
I
up?
represent Loriana Sola Gomez, Judge, the homeowner of the
Okay,
home whose home is set to be searched, and I'm here to assert his Fourth Amendment rights not to have his home searched without.
well, it's not a search.
Uh,
I'm not allowing anyone to search anything. It's just a walkthrough to get the kind of the lay of the land of the house is my understanding. So I think there is a distinction with regard to that, and
It
go ahead.
be difficult, Judge, but I mean, the Fourth Amendment, there's no case law that makes such an exception for law enforcement or anybody to just walk through a home and start photographing stuff, and I absolutely object. This person has a Fourth Amendment right to be free from searches, and entering the home is a threshold search issue. And this court has ruled on that in lots of occasions. There's not some imminent threat. There's not some safety sweep. This is a fishing expedition for evidence in a case. And we're asking the government and another parties or a party to a case that my client's not a party to's lawyer's team to be able to enter his home without his permission. And your order specifically says he's got a right to assert his Fourth Amendment rights. I'm here asserting his Fourth Amendment rights.
Your Honor, if I may, the Fourth Amendment protects against unreasonable searches. Given the fact that there might be potential Brady evidence, again, my client is facing potentially up to 40 years in prison. So I think, while of course Mr. Laureano does have Fourth Amendment right, I'm not arguing that he doesn't. That's clearly balanced here. And I'm not the state of Texas, so I wouldn't be able to press charges or on anything that is found there.
Request a
Yes,
search warrant.
yes.
Your Honor, may the state be heard on this matter? First, let me say that I've just, while we've been here, placed my hands on this file. This order came to my attention yesterday when an email was forwarded to me. And so I backtracked a bit to find out how this all occurred. And my initial concern is that the way the order is written, it does seem tantamount to a search warrant. And our CCP 106 says that no person shall be deprived of their right to remain free from seizure of their persons in their houses, their papers and possessions, from unreasonable seizures or searches. Not only was the state not given notice of the motion that was provided to the court in order to have an opportunity to have notice of what was being required or an opportunity to respond in writing.
Well, I think they were. I mean, we were here on this motion previously.
Yeah,
It went,
Kobe argued. that
Yeah, there
very
was an
much
argument.
the same arguments that they're both making, both attorneys are making,
so
were made
so
back
here-
then.
here's, let's, everybody stop.
Yes, sir.
Here's what we're gonna do. I'm going to hold the enforcement of the order at this time. I'm going to do some of my own research based on the objections that have now been lodged by the assistant district attorney as well as Mr. Gertz on behalf of the homeowner. What I would like is for everyone to do a short brief on the matter and get that to me within a week or so, and then I will make some type of ruling and we can come back and at that point, Mr. Gertz.
Judge, may I make a proposal as sort of an offer and compromise? If the defense would like, I could have my investigator, who's a former Texas Ranger, go and photograph each room in the home. And at the defense expense, it probably costs $300 total or something, but photograph each room in the home. And come back and give an affidavit saying these are true and accurate photographs, and we could do it as a business records affidavit, so it'd be admissible at trial. And that way there's no state incursion into my client's home, and there's no other incursion into my client's home. And yet it's a trustworthy source. You know who I'm talking about. And my investigator could come and give us one statement or whatever, proving up the photographs as well.
Your Honor, it seems like we're just the purpose of that would only be to delay. My initial my initial motion, Your Honor, was just my investigator at the defense's own expense. I didn't ask for the state's investigator. That was something we compromised on. So
That's what I ordered so that the homeowner would have
Right.
that level of
Right.
comfort, which is one of the things that Mr. Hoppower, but
Right.
why?
which
so
I don't
hold on.
oppose. Yes.
Hold-
Sorry. Your
If, if what you're going in for, which I said is not a search and not touching or moving anything, but just to visually inspect layout of the home, then
Yes.
why would there be any issue with allowing Officer Best to go in and
The judge basically pauses the whole thing and says, everybody brief it. I want case law. That's a smart judge move. Slow it down before somebody gets a mandamus writ or an appeal issue. And then we get the compromise. Use a neutral investigator to document the layout so nobody can claim state intrusion.
Take pictures, even potentially a video just of the lay of it, so that there would be, I would ask if he did that, pictures and a video. He could come in, swear, and then that would be the same thing that I was going to allow y'all to do. And that way there's not your people going in. If he's willing to offer that, I think that probably sounds like a good compromise.
We could do it by the end of the week. We can be just done with it.
Well, look, Your Honor, I don't, and I appreciate the council's suggestion. My only thing is, because we live in a world full of human beings. I'm not saying that I don't trust whoever their investigator is. It's just I don't see what the issue would be with allowing my
Fourth Amendment.
Sure, Your Honor, sure.
So if we're gonna avoid a Fourth Amendment issue and me getting mandamus or whatever could potentially happen if I force this issue, and there's an easy way around it where I'm potentially not gonna get in legal trouble, then I like that idea.
Okay.
And so
And
I
I'm
would.
not trying to get you in legal trouble, Judge. Just trying
So
to-
what I'm going to do at this time is I'm going to modify the order that I previously entered. And I'm going to take Mr. Gertz up on his, if you're willing, obviously, if you were going to pay your investigator to pay, I'll let y'all get together with the investigator who is a very trustworthy person. He was a former ranger. He comes in and does stuff all the time for different attorneys on both sides of the table here in Jefferson County. So if you guys can get that taken care of, I'll let y'all visit, get that done. I want thorough video, so that somebody would know exactly how to potentially lay out a house, pictures of the rooms, every room, and a thorough video of the house. And if you guys are willing to do that, then I will modify the order that is what's going to take place and get that done within, I would say, 2 weeks. Okay.
Your Honor, I would concede to allowing, that ranger, but I would ask for a specific deadline within a week, just given that it's been.
Well, I just said 2 weeks, so we're gonna get it done within 2 weeks. It's already Tuesday.
Can we have it the 24th, just so I have there's like a concrete date? Your Honor.
I'll give you a date.
Thank you.
No, we're on the 10th.
Yes, ma'am.
Let's get it done by Friday, the 20th. Mr. Gertz, Friday, the 20th, that's the rest of this week and then all of next week. If you'll get that done
Yes, sir.
and that information. And what I would ask is if you would make that available to both Mr. Salinas as well as the Assistant District Attorney.
Yes,
That
sir.
way they both have any information so that if he's talking about something, she also has a copy of it. That would be great. All right. I'll make some notes. So what I'm going to do, well, yeah, I'm gonna make some notes. Do you have my signed copy? Give me that one. Yeah, that would be better. So what I'm going to do is make some modifications on that order, date it today, with what that order is that I just did, and I think that avoids all of those issues.
Your Honor, if I may.
Yes, ma'am.
I think it might be prudent to also order that there be no alterations to the home of Mr. Gart's client prior to
As of right now.
this being effective.
Sure. So I would ask Mr. I'll make that a part of the order. And here's the thing, I don't think I can really order them to do anything. They're not a party to this suit. And so I would ask that you please have your client cooperate
Yes.
with not making any changes of substantive. Obviously, they're gonna live in the house, but no major changes before that's taken care of. If they would go along with that, that would be great, but I don't know that I really could order them to do so, but I will make these modifications and then we'll reset it. Probably what I'll do is about a 45-day reset instead of a 30. That gives you the time to get that information back and then to kind of all get on the same page, and we'll see where we are at that point.
Thank you, Your Honor.
Okay, thank you. Thank you, Mr. Arch. Thank you, Mr. Salinas.
Thank you.